UK law on site in Singapore at the Norton Rose Fulbright Law Office here in Marina Bay, the downtown core area of Singapore. And with me, we have Wilson Eng, who is the partner and also the head of the Asia Regulatory Compliance and Investigations Practice. And we also have Jeremy Lua, who is a dispute resolution lawyer and also a former Deputy Public Prosecutor with the Attorney General's Office, or rather Chamber of Singapore. Right. So thank you both for joining us today.
Thank you. Thanks, Jane, for having us.
Yeah, so, since we last talked about having this interview was back in July, it has been quite a busy few months for the both of you. I understand that you have been traveling and sharing your insights with your clients around the region. So very grateful that you are able to spend some time with us to share some of these insights with our audience. So thank you very much. So today you will be talking about the latest in cybersecurity and data protection regulations in this region, right? And so when we talk about regulations and cybersecurity, data protection, most people will tend to think, GDPR, right? Or the various national specific computer misuse laws, right? But we will also talk about the current cyber threat landscape because there are very much real life case studies of how we respond nowadays to regulatory inquiries, investigations, questions, and so on. So Wilson, earlier you touched very briefly on the cyber threats, right? We also hear that with remote work and virtual, IT support assistance, and also many companies migrating or accelerating their migrations onto cloud. All these add to the vulnerabilities, or rather the attack surface for cyber threat actors to exploit. And for the Wilson, for the legal sector and the sectors that your clients operate in, can you share with us some of the cyber threats that you have been seeing? I'm just guessing, it's kind of like the phishing, social engineering.
Yeah, sure. I think you're absolutely right. Digital transformation has increased that available attack surface area for organizations, for threat actors to exploit. So it's a question of numbers, I would say. In addition to the increase in available attack surface, there is also that human element to consider. So in the past 24 months, the reality is that there was rapid digital transformation due to disruptions brought by COVID-19 at the workplace. Digital solutions were adopted as a matter of necessity, and we have adapted reasonably well. But at the same time, there are also gaps in the human processes that threat actors were able to exploit. So just to give an example, in a case we were engaged on by a bank, an international bank, to assist in the recovery of over $500,000 from a really sophisticated attack by a threat actor. So what transpired was that the threat actor gained control of a bank customer's email account, conducted a lot of reconnaissance work, learned about the company's operations, banking relationships, even how emails were written. And thereafter, the threat actor then sent the bank a really falsified company document saying that they were authorizing the bank to add a new signatory to the account.
Wow.
Now, the document indicated that a new signatory should be given access to online banking facilities and to be able to really transfer funds as needed. And there were also forged signatures on all these documents of the business owners of the customer. So eventually, what happened was that the threat actor managed to instruct the bank to transfer funds between accounts into one main account and then siphon all that off to Singapore. Wow. So by the time the bank customer discovered what had happened, the funds were depleted. The third-party bank account that received those monies had also been dissipated. And I think ordinarily in a pre-COVID environment, there would be transactions that involve these additional signatories will be carried out face-to-face. There'll be more verification. But as a result of working from home, and I think some of the lapses in the procedure and additional work being needed to verify, that wasn't followed entirely, and therefore there was unfortunate incidents like this. And as you said, there are also spear phishing type of matters. We've had, again, a client who received instructions from a supplier to direct payment to a new bank account for an outstanding invoice. Ultimately, that amount was pretty large, but more than $1 million. But ultimately, it transpired that it was because the supplier's IT systems got hacked. The threat actor was able to identify an actual payment that was going to be made, that was due, and then spoofed certain email accounts to carry on these communications with the clients, and the funds unfortunately were diverted. So again, verification could have been done, more steps could have been taken, but in the circumstances, perhaps understandable that why they were not taken or should have been taken. But ultimately, I think we need to think about how our staff and our people should not be the weakest link, and that systems should not be compromised.
Yeah, I think it's also quite a challenge for many organizations to sort of able to adapt to all these last-minute changes in work practices and work habits, and also as standard operating procedures. So everything operated within the same time frame as before COVID, but all the infrastructure, all the processes are all different. So it had been quite a challenge for organizations. But I think that with all these mentions of phishing attacks and spear phishing in the media, and also some of the good case studies that we can learn from, I hope that many of us can recognize some of the signs of a spoof email or a website that claim to be from a legitimate organization but is not. So you touch on spear phishing and phishing, and we also hear that supply chain risk is also quite big during the COVID times, of course, colonial pipelines and all that, right? And also that touches on this concept of third-party risk. And when we talk about third-party risk, we come across this report in the media about the Razor versus the Capgemini case. And can you tell us a bit more about that? I know that you cannot share a lot with us today because the case is still before the courts, but what is in public domain in terms of third-party risk, and what lessons can we learn from it?
Yeah, that's obviously a matter that was prominent in public media, and we can't comment on it substantively because it's before the courts due to client sensitivity. But we can certainly talk from a broader perspective and comment on third-party risk. I think digital supply chains can be really a point of weakness for organizations. The chain reaction from a single attack on one supplier can compromise a whole network of providers and organizations downstream. So I think that's to be really considered quite carefully. To put in things in context, if, for example, a vendor is engaged to supply and maintain, say, IT infrastructure for a company that has operations in a region, and the vendor seems to be reputable, for example, a large listed company. Yeah. But if it transpires that the vendor has failed to carry out patches for the relevant infrastructure, and the company then gets attacked because the threat actor exploited a known vulnerability in the unpatched infrastructure, then we would ordinarily regard the vendor to be at fault. But trying to obtain recourse or even assistance may not be so straightforward, especially when a company may have signed up to standard form contracts with that vendor. So, for example, the contract may stipulate that the vendor makes no warranty as to the security of the appliance or meeting of any standards, exclude liability for negligence. So it's common for these contracts to really only focus on service availability and service levels, but not necessarily on cybersecurity. The contracts may also not oblige the vendors to keep certain critical logs that will be helpful in determining how the cyber attack took place. And if these logs are not kept, then it's hard to conclusively establish that it was the vendor's failings that resulted in that incident. Contracts may also have, quite common for us to see, liability caps, and caps or limits on liability to certain amounts or multiples of the value of services provided, sometimes only 2 to 3 times. That can restrict the ability of the customer to go after the vendors for compensation, especially if the incident and the cost of remediation is particularly high in the instance of a ransomware attack, for instance. And so that actually puts most organizations in quite a difficult position when using vendors when they are subject to contractual terms that may restrict their ability to have recourse or to claim. And these considerations, which are contractual in nature, need to be also overlaid with an organization's obligations to third parties, its own customers, as well as to the regulator. So, for example, in Singapore, the Personal Data Protection Commission, or PDPC, requires organizations who use intermediaries to put in place contractual provisions to ensure protection of personal data, where these organizations are using data intermediaries to process data. And there have been a number of enforcement decisions where organizations were penalized for failing to put in place these contractual safeguards. And customers, especially those with intellectual property assets in their possession, may expect to be notified and want to audit how these assets are being protected and how vendors are being managed. So I think those are sort of really key things to consider when dealing with third-party supplier risk, particularly from a vendor perspective.
I think it's quite a lot of takeaways and points that for our audience when they listen to this to sort of make sure that they consider when they onboard a vendor. And of course, also when they are developing an overall approach to third-party risk management. So coming to the regulatory actions, right? In this, for some of our cybersecurity professionals or data protection professionals who are developing, say, incident response playbooks or crisis communication plans, when faced with such an incident, when there's a breach happen, right? One of the immediate action, of course, is to notify the relevant parties about the breaches. But the common question I believe that many would, have is what is considered as a breach. The reason why I ask this is because some may say, right, we see some suspicious scanning activity on the network, but we are not sure if data had been accessed, or we know that the data had been accessed, but we are not sure that it has been exfiltrated. So those are kind of the sort of ambiguous, I guess, situations where people think, is it a breach? Do I have to notify, my customers, the regulators? What is the regulations around this?
Sure, and I'll ask Jeremy to sort of expound on it, but I think before we get to the point of notification to the regulator or to the data subjects, it's key to emphasize that from the personal data perspective, the data that is at breach has to be personal data, and right. It has to be within scope of the PDPA. And then beyond that, there are certain aspects whereby data can be considered to have been breached before we decide whether it is to be a notifiable breach. So maybe, Jeremy, you want to talk about breach and then notifiable breach.
Yeah, so this is a very good question. When is it considered a data breach? Because in a cybersecurity program, you ought to have various other measures that will allow you to potentially arrest an incident as it takes place, right? So an incident can be, incidents within the various cybersecurity frameworks, classed fairly broadly. It's meant to capture, various events. But where data breach is concerned, we have to look at it from two angles. So first, what does the law say, from a regulatory notification perspective? In Singapore, the PDPA defines a data breach to include a number of activities. So it includes access, unauthorized access, modification, alteration, and so forth. So we need to track that very carefully to what actually the forensic evidence and the forensic artifacts tell us. And that involves working very closely with forensic consultants, lawyers and consultants, trying to determine factually what has occurred and whether or not the degree of confidence we can get to determining whether or not an event is a data breach, at least from a regulatory perspective. Because once you assess that it's likely to be a data breach, all kinds of obligations kick in, right? You have 30 days under the PDPA or rather reasonable time, but which is interpreted as 30 days under the various guidance issued by the PDPC to expeditiously assess whether or not it is a notifiable data breach.
Right.
Then another 3 calendar days for you to make the notification if you had made the assessment. Your contracts will also be another area of focus. How do you define a notifiable incident? So it depends on the level of granularity that is defined in the relevant contracts that you might have with your customers. And
Okay.
that would determine your notification obligations. One thing that companies and organizations need to do is don't jump the gun, right? You need to know what exactly happened with reasonable level of confidence before you notify a regulator or any other third party, because they are going to come back to you with questions about when it happened, how it happened, what exactly was breached, what's the nature of the breach. And if you go off without all these answers in hand, then you might be shooting yourself in the foot.
So just picking up on that point on notification, and Jeremy focus on the contractual obligation to notify in certain cases under the PDPA. Of course, if it were to be after the period of assessment, it's decided that it's going to be a mandatory notification to be made to the regulator or the data subjects. That tends to fall within two considerations of notifiable, of significant scale and significant harm. And significant scale meaning that if the data breach is one of a large enough that has a significant impact on the organization and its systems, then that will be treated as significant scale. Generally, when more than 500 data subjects are affected, then that will be treated as such. Significant harm is yet another factor that will have to be considered in terms of the types of data that have been impacted. And it may be sensitive data, and the law again has certain guidance around what kinds of data would constitute significant harm. And that could include things like very sensitive medical background information, insurance and healthcare information, past criminal records as well. So all that would need to be considered in the notification assessment. And early on, Jane, you referred to what kind of activities may constitute a breach, and Jeremy said we have to track it very closely according to what the law requires, and that's absolutely right. You also asked, what about exfiltration, and what about what if it's not exfiltrated? So I think that's where we don't want to fall into a binary decision of saying if it's exfiltrated, then yes, you have to notify. If it's not exfiltrated,
Right.
you don't have to. That's not necessarily the case, because there have been instances where data have been accessed but not exfiltrated. That is still a breach if the access is unauthorized. Data can also be encrypted but not exfiltrated.
Correct.
That
That's
is
right.
also taken to have been unauthorized the handling of data, and therefore a breach. So we need to look at that all quite carefully. Now, obviously, exfiltration, which is the transfer out of data, that would also constitute a breach if it's unauthorized. That would also carry with it that much more risk because of the dangers of that information being potentially leaked on the dark web or the internet.
Right.
And it carries with it additional exposure. But the baseline threshold of data breach is actually quite low. Anything that is unauthorized from a handling of data could constitute a data breach. So that's where we have to not impose artificially high thresholds on what may constitute a data breach. You've got to go back to the law.
Right. Yeah, as Jeremy also mentioned earlier, don't jump the gun and think that, if we see some suspicious activity and the data may or may not be accessed, it may not be considered as a notification, mandatory notification action. So we just talked about breach notification when it comes to a data breach, and if we may reference another sort of cyber threat that is quite prevalent nowadays, which is, of course, ransomware. And that has also been mentioned by the Cybersecurity Agency of Singapore in its Singapore Cyber Landscape 2021 as one of the top cyber threats that we face, not just in Singapore, but also in the region. So, but before we go into sort of the regulatory actions when it comes to ransomware, maybe, Jeremy, if you could touch very briefly on, the cyber threat landscape that you're seeing with regards to ransomware from a legal sector and also the sectors that your clients operate in.
Sure. What I'll say is that, just if I were to use one word to describe the trend, it would be one of continuous evolution, sort of tracking with, threat actors in general. In the 90s, it started out with threat actors tinkering around, the internet was still a new thing. So you've got accidental discovery of vulnerabilities, exploiting it for, very sometimes fun, to make a political statement, and then sort of evolving into what now we see as more organized crime. And that's the same for ransomware. I think over the years we have now come into this ransomware kind of age, I suppose, so to speak, and it's now a trend known as ransomware as a service. So different parts of the ransomware ecosystem
That's right.
has developed specialization such that a threat actor or criminal group may not necessarily be good at all parts of it. They may be good at intrusion, they might be good at negotiation, they might be better at exfiltrating the data. So, but each element of the chain, there's some level of specialization, and certain criminal groups would go out there, obtain it as a service, much like software as a service, and we see that professionalization in well, I wouldn't call it professional, but that specialization and corporatization of
Okay. Commercialization, maybe.
yeah, and if you were to engage and interact with some of these threat actors during negotiations, they work almost like a service desk.
That's right.
They will have a first level escalation. If you want a discount, they need to go up to third level escalation, and then understanding that helps perhaps with the negotiation. And the other trend is that we see previously ransomware just sort of like a broad brush attack. You send out a script and then it goes out infecting computers, and you get a screen that comes up. You make a payment, maybe you might get decryption or not. That was sort of stymied by the fact that companies caught up and say, well, if I have good backups, I can ignore those
Right.
attacks.
Yes.
The threat actors got more realized that that's not working anymore, and they evolved into what is a name and shame approach, right? And that changes the calculus for organizations and having to deal with them. And with ransomware payments, and I think we'll also can speak a little bit more about it. There comes a different set of laws to consider as
Exactly.
well.
That's right. So do you want to touch on the regulations, regulatory actions that cybersecurity and data protection professionals have to consider when it comes to ransomware?
Yeah, I mean, as Jeremy said, is the sort of commercialization of ransomware attacks is of a great concern because there is a lot of sophistication in how these attacks are being carried out. But from a legal perspective and a regulatory perspective, I think law enforcement agencies and regulatory authorities are keen to stress that companies should try not to pay ransom whenever they're being attacked, partly because this would actually continue to support and facilitate more
That's
of
right.
these attacks taking place. The threat actors may also not be reliable. It could create the
course.
payer to be a soft target for further attacks. And I think all that is well taken considerations. At the same time, I think for a company that's undergoing an attack of that nature, there's tremendous stress on the business and on the individuals concerned, and sometimes lives could be at stake if we're talking about healthcare situations
That's right.
and energy and significant matters being considered. So that is where considerations of the law needs to be quite detailed in terms of whether payment can be made, and if payment were to be made, then how should it be properly made? What kind of steps ought to be taken to carry out the relevant due diligence to ensure that if payment is made, is being made to a party that is not sanctioned, for example, and not therefore creating new issues of its own, that by paying ransom to, for example, a terrorist organization that has been sanctioned by one of the regulators, for example, the US Office of Foreign Asset Control, or OFAC, then that would be steps that need to be taken, the due diligence that need to be carried out to ensure that any kind of payment, as reluctantly made as it may be, it doesn't trigger further legal issues for the
That's
company.
right. Yeah. I think a big lesson for many in the cybersecurity world is that we need to actually put more focus on backups and make sure that, even if the backup had been ransomed, that you have a backup for a backup. But I think that is quite a conversation, detailed conversation for another day, as well as all these sanctions and how you carry out anti-money laundering sort of procedures to comply with some of these sanction laws. I think that's also another topic for another day. And another topic for another day, of course, is also briefly you touched on, Wilson, earlier, that we are talking, when we talk about breaches, and we are really focusing on personal data breaches and rather than corporate. And talking about corporate data breaches, that's of course another day's topic as well. So quite a lot to cover really. And I think we can't really cover everything today, but you have given us a lot of food for thought for our audience. But a final question before we wrap up this conversation. Jeremy, briefly earlier you talked about the Chinese regulations, the Chinese personal information law that came out late last year, I believe, yep. And also the Thailand's Personal Data Protection Act that also came into force in June this year as well. Yep. Any other sort of top takeaways for our audience in terms of not just from a data protection perspective, but also from a cybersecurity perspective when it comes to all these emerging regulations that we're seeing in this region?
Sure. I think in order to comply with, let's just start with the premise that these new laws are just the first of many that will come, right? There is a greater emphasis on use of data ethics, and as companies and the world innovates further, with more data that they have, there is this sense that, governments need to hold companies to account when they use for data, and therefore we expect further regulation in areas relating to AI and the like. But what a company may be able to do will be to start understanding what data they have, how they use it, and then starting from there, they are able to then think of how they can comply with regulations. And it might well be, not just internal practices, but also how their supply chain might affect
of course,
them.
Yeah.
And I think that's a good starting point for companies to be aware of, because I think gone are the days where you just collect all the data that you can have, right? Now there's a great deal of responsibility expected on how you manage and how you deal with the data that you have.
And Wilson, any last words of wisdom for our audience before we wrap up the podcast?
Yeah, I wouldn't say any words of wisdom, but I think just to look into the future, as Jeremy said, apart from all these evolving laws and data protection, I think one aspect of development will be the specific protection of an individual's right, and therefore the creation and the support over a private right of action. Because right now what we have seen a lot of would be regulators going after organizations for breaches. What we are going to see increasingly more of would be individuals going after organizations as well.
Interesting.
And recently in Singapore, in a case that went up to the Court of Appeal, the courts actually overturned an earlier judgment and ruled that a private individual has a cause of action for emotional distress. So it's not just pecuniary or monetary loss and damage for which an individual can make a claim, but emotional distress can amount to a head of loss as well, for which damages can be claimed. So I think there is this sense that data privacy is something that can affect a person's well-being, emotional well-being and mental state. And if there were to be any impact and distress caused by that, then the law recognizes it. I think this will start to grow, and I think as more matters get brought forward, when there are unfortunately more data breaches that may occur, individuals are going to know what their rights are, and that's an area that we will look at on the horizon.
Oh, okay. So it sounds like it will be quite a busy few years for you and Jeremy to deal with all these individual cases that's going to be coming out before courts. So thank you very much for your time today, Wilson and Jeremy. I think that's a lot of takeaways for our audience when they formulate their incident response plan, crisis communications, and also hopefully when they deal with their in-house counsel, they know, the kind of considerations that their lawyers are talking about. So thank you very much for your time again today.
Thanks, Jane. Much
Thank you.
appreciated.
Thank you.
Thank you.